Welcome to episode 3 of Truck Case Mentor. I'm Fred Burkey, and today's topic is intellectual technology. Let's get started. Knowledge can come in the form of learning new techniques for depositions, learning persuasion theory, or what I call persuasion theory, or learning new and better techniques to try your cases. When you're handling a truck case, intellectual knowledge is also having a deep understanding of truck law. Having that depth of knowledge can help you win the case. To illustrate, I once had a case involving a young lady who was disabled and a ward of the state. She was being transported in a shuttle van or shuttle bus from her daycare center to the home where she spent her evenings with her guardian. One day when she was being transported by this shuttle bus, the bus was crossing an intersection and was hit by a passenger car. It caused a catastrophic accident, and my client was critically injured. Now, at first instinct, a trial attorney might assume that the responsibility rests solely on the passenger vehicle that crashed into the bus. But in looking into the case deeper, I realized there could be an alternate theory that would provide a much better opportunity to get a successful recovery for the client because she had been severely injured. In that case, the insurance company assigned outside counsel, which is common in that type of a case, to represent the passenger vehicle that hit the shuttle bus. Outside counsel was not familiar with truck law. They represented their client not having the benefit of trucking knowledge or any of the rules or regulations that applied. So when I got to taking the deposition of the owner of the adult care home who operated the shuttle bus, I began to question them about their responsibilities as a motor carrier to qualify, train, and supervise their drivers. When I began to ask these difficult questions to the owner, he confided that he had never provided any type of training or supervision for his drivers and just simply assumed that the driver having a license was all that was required for him to operate a shuttle bus with passengers that included perhaps 15 people. I knew that once you looked at the statute, a motor carrier was defined in that case as a company that transported passengers for money. There was no exception for the motor carrier that would take it out of the statute, so hence they were a motor carrier. And as a motor carrier, they were required to do these basic things: qualify, train, and supervise their drivers, which they admitted in deposition they didn't. The owner and his attorney treated the case like a road wreck case. And the benefit of that lack of knowledge, lack of intellectual technology, if you will, created an avenue for me to get to the truth of the case. Because we've all had the experience when we get a deposition of a key defendant in the case, and he's been seasoned and well prepped so that he never admits to facts that are important for us to prove our case. In this case, that lack of knowledge by the defendant's attorney helped turn the tide. They just never stopped to consider the fact that because they were a small company, they weren't a motor carrier and they weren't responsible to comply with the regulations. So the way that broke down in that case was the owner of the care home hired a driver who happened to work two jobs. In that case, the driver had just finished the judge shift late into the evening, left that job, and then went on first of the morning, perhaps at 7 in the morning, to work as a driver for the care home that ultimately transported my client. So he had a fatigue issue, which is common in truck cases. And this case was no different. The difference was that in this case, the owner just assumed he wasn't responsible to manage those hours of service or to make certain that his driver wasn't fatigued. He didn't do that, and that created responsibility on behalf of the care home for the crash. If you were just to look at that as a typical road wreck case, you'd only be focused on the passenger vehicle that struck the bus. But if you look deeper with that intellectual technology and that deeper knowledge of truck law, You begin to find the safety deficiency in the system. The safety error in this case was the fact that there was no supervision over the driver. Once that was established, the case settled for a very good figure in mediation without having to go to trial. So here are the takeaways you can take to your desk. 1, always work to have a deeper knowledge of truck law. 2, understand the federal motor carrier safety regulations. 3, understand how the federal motor carrier safety regulations apply in your state. 4, look past the driver's conduct. And 5, always seek to find responsibility on behalf of the motor carrier. If you have any other questions, or if there's just some additional information I can help with, feel free to reach out to Fred at TruckCaseMentor.com.